But here's the thing. What the court was basically saying in this case, which made it a little hard pill to swallow, was that you, lawyer, better know every single possible case pending cert or even working its way up to through the
Yeah,
Court of Appeals
you better be
because
clairvoyant. Yeah.
if the yeah, you need a crystal
Um,
ball.
you need to be omniscient and clairvoyant.
Yes, because this issue this is a crime today, but tomorrow it might not be. So you better make sure you've you know prepared for that. The point is, we can't know every case, every issue, everywhere, but we can put this one on the radar of every lawyer. So this is pending cert, this Thompson
Mm,
case, and it's not just about this one statute. It could have far reaching implications. So if you have a fraud case of any kind, you should take a look at this. Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. It's late on a Friday. Well, hello, everybody. Doug Passon coming to you from Studio 3553, late on a Friday in Scottsdale, Arizona. Guess who's back? Guess who's back? I haven't had my good friend and colleague Mark Allenbaugh on this podcast for far too long. We had about I don't know, 30 different topics that we wanted to do podcasts on, but today we are settling on something about I don't know, truth versus lies, we would call it. We're going to talk about some developments, some really important, significant
yeah.
developments in federal fraud slash false statement type cases that really could have some far reaching implications. So I'll just set this up. Some people, I mean, say we're living in a post truth society now where alternate facts are a thing. But when I was a kid, my mommy told me that lying was bad. And, the government certainly thinks so because if they catch you lying, in a business dealing or in a banking endeavor or I don't know, a criminal investigation where they're asking you questions, they're going to come after you and they're going to charge you. And it's going to be bad. It's wire fraud, it's mail fraud, it's false statements, you name it. And up until recently, I think you would agree with me, Mark Allenbaugh, that it's fair to say that if the government knocks on your door to talk about false statements, you are most likely freshly
Screwed.
and fully fucked. Yes. Yeah.
Yes.
Yeah. So, but maybe, as the great Bob Dylan is likes to say, the times they are changing. I don't know. So there's been some pretty big shifts, and that's what we're gonna
Yes.
talk about in the most recent one. And we're probably going to work backwards and incorporate because there's a whole body of Supreme Court case law that every criminal practitioner and heaven forbid somebody charged with a fraud or false statement situation really needs to have on their radar. And this is a set for sentencing podcast, so we're going to talk about really this in two big prisms. We're going to look at this through plea negotiations. And the most obvious aspect of that would be maybe you don't want to plead guilty at all because maybe what you did is not a crime. But there are a lot of nuances when you're negotiating pleas that we want to talk about. And then there are sentencing implications under the federal guidelines. So that's what we're going to talk about. And I guess I'll just throw it to you. What was the catalyst, the impetus for this conversation?
So this was just whenever the Supreme Court issues its Monday morning orders of cases that it is denied cert to or granted cert, I always like to look and see what's new and different. And a couple of weeks ago, Friday, October 4th, and the Supreme Court has been doing this more and more, is issuing some of its cert grants on Friday afternoons and or Friday mornings. And it issued one for a case on Friday,
Okay,
October
wait.
4th.
We have to assume that there's at least two listeners who don't know what a cert grant is.
Oh, that's just the court agreeing, the Supreme Court agreeing to hear the case.
Okay.
And generally, they will only hear cases where there is a split among the circuits as to, a particular important legal issue. One set of circuits go one way, and one set of circuits go the other way, and
Okay.
so they come in to resolve that.
All right.
Um, so that's what it. So that's what it. So it was an interesting case. The case is Thompson versus United States. The docket number, if you go to the Supreme Court's website, you can find it, or look the case up. The docket number is 23-1095, and it came out of the Seventh Circuit, and it's what I call a sleeper case.
And by the
Usually,
way,
yeah,
I'll let you give the facts of the case, but I
yeah.
love that it's a fraud-based case based out of Chicago involving some of the family of former Mayor Richard Daley. But
Well, you go ahead. You're stealing my thunder now.
well, oh, sorry. I just love that. Okay, it's good.
Yes.
We got it's a little celebrity. We got a little, but what are the facts? What happened?
Okay, so the facts here was the I think it was the grandson. He was the grandson and nephew of some of the Dailies, the Mayor Daley and the Governor Daley, I think, from
Okay.
Illinois. Who those guys have had their own um, issues with the federal government, shall we say? Anyway, this particular Daley Thompson is the last name, Patrick Thompson. He bought a house. Excuse me. He needed a loan, and he goes to his local bank and he signs a loan for $110,000. And
Huh?
then, and it's not really clear from the record, he's able to get a couple of additional loans for a total of $219,000 now. So he has three loans totaling $219,000. But these other two loans that he gets, they're not papered. He doesn't sign a promissory note or anything for them. So there's
Which is
some weird.
weird. Since when do
Yeah,
you
it's
get to
weird.
go into a bank and get, 109,000, whatever,
Yeah.
and they're just like, no paper. Like, here,
Yeah, so
just
no
pay
paper.
us back
Yeah,
when you
yeah, yeah.
have
We
it.
we've seen you before.
Okay, yeah, that makes good
Here's some
sense.
money.
So
So
he's got 110 that's papered
yeah,
and
and
another 109 that's
that's
unpapered.
that's unpapered. Yeah,
Okay.
and surprise, surprise, there's some shenanigans going on at the bank, and the bank goes belly up. FDIC comes in, takes over, and starts going out to all the debtors that the bank had lent money to collect. And they find him on the list, and they say, "Hey, according to our records here, you owe the bank $219,000." And Thompson says, "I owe $110,000,"
Uh-huh.
and that's the question.
Uh-huh.
So he says, "I owe 110,000 bucks," and they say, "No, we have the records say $219,000." Says, "No, I don't have any records of that." Just true.
And I see a
I
quote in
only
your
have
article. He says,
Yeah,
quote, and that any higher amount was incorrect.
right. And any higher amount is yeah, he says that too. Any
Okay.
higher amount. Oh, yeah, I wrote an article coming out in Law
Yes,
360.
yes.
Yeah, thank you. You probably know more about it since I haven't reread what I wrote. I
I've read it
forgot.
fresh in my
Well,
preparation
thank you.
because I'm anything if not a thorough preparer.
Oh, well, good. Excellent.
Yes.
So long story short, and I again, this is what I call a sleeper case because there are no amicus. Usually, when there is a big issue that can impact a lot of cases and what have you, especially a big criminal issue, you'll have a lot of amicus briefs, such as NACDL or the ABA or some other organizations will get involved. Nobody, no amicus.
Okay.
And
And for the two listeners that don't know what an amicus brief is,
so
what is that?
basically a friend of the court brief. So if it's a really important issue of criminal law, you'll get like the large national organizations will weigh in, and they'll file briefs usually in favor of the petitioner about why the court should take the case, and and how the court should decide the case. And like I
Okay.
said, organizations like NECDL or ABA and what have you,
Okay. So this
or
dude went to
FAM.
trial, by the way. He went to
Yes.
trial and got convicted of both
So
counts.
right. So he was charged with an unusual statute 1014, 18 USC 1014. And what that statute says is it's illegal to make a, essentially, I'm paraphrasing here, it's illegal to make a false statement on a loan application.
Yeah.
Okay. And so he was charged with 2 counts of that for ostensibly, I think the 2 additional loans, but basically the false statement that the government alleged that he made was that he only owed the bank $110,000 and nothing more, and plus that the money that he was going to use the proceeds for was for, I think, home improvement or something like that.
Hmm.
And he lied about that also. So he goes to trial on this. Usually, a case like this is charged as wire fraud or
Right.
or mail fraud sometimes, but generally, and there's also a bank fraud statute, and you could do that too, or even I guess that 1,000, probably not a 1001, but either bank fraud or wire fraud, not this weird 1014 statute, which I had never seen before until this particular case. And so anyway, he goes to trial, he's convicted, he goes up to the Seventh Circuit, and what his argument is, it's like, look, the statute says false statement. I did not make any false statements. I may have been misleading when I said, I agree, I owe $110,000, but nothing more. That's misleading, but it's technically not false.
Yeah.
It was, if you will, it was a half truth. And
Yeah.
I may have omitted some things.
Yeah.
Omitted the context, certainly misleading, but it was not a false statement.
Yeah.
The Seventh
Yeah.
Circuit,
And
go,
by the
go ahead.
way, if he said any higher amount was incorrect, because that's what you have in quotes,
Yeah,
that's that's not him saying I don't owe more money. It's just saying whatever you
right,
said
right.
about a higher amount is not accurate.
Right,
So it's a
because it
miss.
wasn't
So
papered.
so
Because it
he's
wasn't papered.
misleading.
Yeah,
He's
yeah, it's
clearly
misleading.
making misleading statements,
Yeah,
or
it's misleading. Yeah,
maybe he thinks that
yeah.
it's incorrect.
Well,
But whatever. It's
it all
not a
depends on what is. But anyway,
yes. All
sorry.
right.
Yeah,
So
yeah,
a false statement would be I owe nothing. I never borrowed any money from the bank. I
right,
paid that back.
right.
Like flat out false. But guess we're in a gray area here because you
Exactly.
know it's
So,
we're talking
so
about
we're in a
misleading or omissions, right?
right,
Yeah.
basically misleading statements or omissions.
Okay.
So he goes up to the Seventh Circuit, and the Seventh Circuit says, okay, fine. Your statements may not have been false; they were misleading, or and omitted some material fact, but nonetheless they still come in, they can still be considered false even though they're not technically false. We're going to find that they were misleading enough, if you will, for those statements to violate the statute, so we're going to affirm your conviction. Well, the Sixth Circuit and other circuits have gone the other way, and they said under this 1014 statute, if an element says false and there's no other element that says misleading or omission or anything like that, then you can't violate the statute. If it just says false, then you can only violate the statute by making an actually false statement. So
Okay.
there was a split. It was the seventh, and I can't remember. It's in my article. There were like 3 circuits went one way and 3 circuits went the other way. So that's why the Supreme Court has granted cert. So here's the really interesting thing, though, is okay, big deal, Mark. It's this weird 1014 count that you're talking about, and most white collar offenses deal with wire fraud, mail fraud, or the 1001 statute for making a false statement to
Yeah.
a government official or something like that. So first things first, I think the reason why the Supreme Court granted this case is because it's going to side with the petitioner. And why do I think that? Because over the last several years, there have been a series of cases, criminal cases, that the Supreme Court has taken to narrow the definition of a statute, or I shouldn't say the definition, but to narrow the scope of a statute in terms of how the government uses it. You and I are very familiar with, for example, Simonelli.
Yeah.
And in the Simonelli case, the Supreme Court said that you cannot prove any type of fraud, wire fraud, mail fraud, etc., under what was the theory, Doug? Now I'm
Right to
blanking out.
control.
Right to control. Thank you.
Yes.
Under the
Which,
right to
which,
control theory.
which is they're talking about the right to control information, but that's
Correct.
essentially concealment. It's I didn't tell you something that if I would have told you, you might not have done this
Yes.
deal with me.
Yes. Yes. Yes.
But
That's
but
very close. So
yeah,
it that's very close to here. And then there was the Snyder case, which I cite this in the article from last term. I think that had to do with the public corruption, and
well, let me
they
see.
never.
I've got your article right here.
Oh yeah,
Snyder does not criminalize gratuities, only bribes.
right. So
And
yeah,
then there's
so
a distinction between what is a gratuity and what is a
in a bro,
bribe, which
right.
we're pretty intimately familiar with that
Yes, we
issue
are.
too.
We are that too. And so before, many courts had interpreted, and the government had interpreted that 18 USC 666 criminalized both bribes and gratuities, and the Supreme Court said nope, only bribes.
Yeah.
And then there was another case, if you're looking at the last term, where it had to do with obstruction of justice. This had to do with one of the
Fisher,
Jace. I'm sorry,
Fisher.
Fisher. Yes, Fisher said that you can only criminalize that obstruction. It had to be of something tangible. Obstruction had to involve you were destroying a document or something
Yeah.
tangible, and
Which I
not
love because that again, I think that's touching on lies, misleading evidence. Like if the
right.
feds sit down and they want to interrogate you and you give them false information, it seems to me that Fisher is restricting that. That's not obstruction of justice, which I don't know if that's fully if I'm being a little too broad in my assessment there, but what I love about that is that we know for many decades that the Supreme Court has said the feds can lie to you all they want in an
Yeah.
interrogation. They can tell you they have your fingerprints, your DNA, 16 witnesses, and all to get to force a confession out of you, and there's not a damn thing you can do about it. But God, heaven forbid you lie to them and now you're going to be on the receiving end of an
Well,
obstruction.
there was the companion case to Simonelli that I cite in the article, whose name I also forget.
Is it Parocco?
Parocco, yes, where you do not owe the private citizen does not owe a duty. What was it? Go ahead and read it.
Dude,
Sorry.
yeah, I'm not smart about this. I just got his article in front of me.
Yeah,
I know how to read. In Parocco,
I can write but can't remember.
Mark Allenbaugh, and I would love to make this article. It's only 4 pages. I'd love to make this article available as a download for this episode, but I don't know if we can because it's not been published in Law
Yeah,
360.
I can't yet, but
But
I'll send you the link. It should be
but
published this
once it
coming
gets
week.
up there,
Yeah.
because Law 360 is a paywall and blah blah blah. But anyway,
Uh,
in Parocco versus United States, also in the context of fraud, Mark says the court held that private citizens do not owe a duty to render honest services to the
Services,
government.
yes. Yeah. So we have
Yeah.
all these Supreme Court cases, and they're narrow
And
cabining.
I know it's Friday afternoon, but you have one more case in here
Oh
of the
yeah,
narrating. Do you remember what it is? I'll give you a
no.
cookie if you can remember. In Dubin versus
Dubin,
United
yes,
States, the
yes,
court
yes,
held that in the context of aggravated identity theft,
yes,
that
yes.
a misuse of another person's means of identification must go to the crux of what makes the underlying offense criminal.
Right.
So, yes, what you're saying is basically the government has all these, well, we can talk about over criminalization till the cows come home, but the government has at its disposal all of these statutes that they could seemingly invoke to get you any way, 6 ways to Sunday if something involves false fraudulent statements. And the Supreme Court has in at least 5 cases that you just cited in there saying, No, we need to rein the government in.
Yep.
This is too much.
Right.
They
Right.
have
And
way too
these are all
much
recent cases. Yeah.
Yeah.
So
So
so I think in Thompson, they're going to rein the government in again, and they're going to say in in the context of 1014, no, the statement has to be absolutely false, misleading, or a half truth or an omission,
okay.
not sufficient.
All
Okay.
right.
Now, Why does that matter? Now, here's where it gets interesting,
Yeah.
because the argument that the Sixth Circuit and some of the other circuits that went the way of that the petitioner wanted the Seventh to go was that if you want to criminalize a misstatement or an omission or a half truth, you have to state it in the statute. And there are, and I give examples in the
Mhm.
article, there are statutes that actually criminalize misstatements and omissions and stuff. For example, I think it's 15 USC 77, blah, blah. Those have to do like with stock fraud, a lot of those stock fraud cases.
Yep.
If you make, misleading, and I think it actually uses the term misleading statements,
Yeah.
those are criminalized. But you know where misleading and omission is not present? Wire
Could
fraud,
it the
mail
darling,
fraud.
one of the darlings, those are the two darlings of the federal fraud
And those are the big,
prosecutions.
and 1001.
Yeah.
Now I can hear somebody screaming right now, throwing their scotch at the laptop. Allenbaugh, fraudulent, fraudulent. That means misleading and all that stuff. No, don't. Because
It don't?
if it does not necessarily, because there's, I kind of point this out in my article, but I don't think I do it clear enough. There are statutes that criminalize making false statements and fraudulent statements, so they must mean different things. They cannot be redundant. We cannot read terms to be superfluous or meaningless into a statute, so they must mean different things. But as, like I said, the Sixth and Seventh, or the Sixth Circuit and other circuits have said, if it doesn't say misleading or omission, then those are not criminalized. And fraudulent cannot also mean what's not said directly in the statute. You cannot
Hmm.
infer in a fraudulent statement something that might be
Yeah.
something that is misleading or
Or
omitted, or an
mission. Yeah.
omission,
Yeah. Yeah.
because those occur in other statutes. And so we always have, I can't remember what Maxim Scalia said this in terms of, statutory construction and stuff, but we always have to, we have to infer or assume Congress always means what it says and
Uh-huh.
uses terms meaningfully and purposefully. And
Yeah.
when a term isn't used, then it doesn't apply. And when it is used, then it does apply. And so some statutes have, because of the fact that some statutes have the term misleading and have the term omission, it cannot also follow that the term fraudulent subsumes those terms also, because there's no evidence of that. There's no evidence that the term fraud in and of itself necessarily means or implies a misleading statement or an omission. It just as easily mean a false statement, in which case, and what I'm ultimately getting at is this term. I think what the Supreme Court is going to have to do soon is really get down to the nitty gritty and what is fraud, what constitutes fraud. But this is where I think the Supreme Court jurisprudence is starting to go. It's been chipping away kind of like at the outer bounds of white collar stuff, white collar cases, but now it's going to get to the core. And this is the first step, the first entree into the nucleus of white collar criminal law, and where this also has an application. So assuming my argument is correct, that if 1014 is, if false, if the court's reading of 1014 ultimately is that only false statements can violate that, and and it can only violate 1014 because the terms misleading and omission are not also elements and are not expressly stated in the statute, then it follows that wire fraud, mail fraud, 1001, and some other popular statutes, those also cannot be violated by merely making a misleading statement
Hmm.
or an omission. Assuming all
Wow.
that's correct, okay, assuming all that's correct, which is going to throw out a lot of convictions. Another big issue is sentencing,
All right. Well,
because
just put a pin in that. We're gonna
okay,
get there for a second.
okay,
But before I do, I would like to put on a grand show for you and show you that I'm erudite too. I know a little Latin and
Uh,
I know a little case law because I think what you were referring to is about Congress when they're writing a statute. Is there's an oh, and I remember this from my moot court days back in law
mm,
school, Cannon versus University of Chicago says that Congress is always presumed to know the law when they make a
mhm.
statute. And now
Yeah.
the Latin, because you love the Latin.
I love the Latin.
I
I'm
had
Catholic.
had a mangled version of this in my head, so I just had full disclosure. I just had to Google it, but tell me if this rings a bell. Expressio unius
Mm.
est exclusio alterius,
Yeah,
which
very good.
thank you. Well, I Googled it, but it literally means the express mention of
Yeah.
one thing is the exclusion of others. Isn't that what
Yes.
it's saying here?
Yep.
If
Yep.
you
Yep.
said one
Exactly.
thing, not the
Y-
other, we get to
Yes.
you intentionally omitted the other,
Yeah.
right? Okay,
Yeah.
good.
And I
So
give examples. I give examples in the article, by the way, of criminal statutes that contain the words omission and
you better put
misleading.
this Latin in your Law 360 article, though, because you can't sound like you know what you're talking about in the law if you don't invoke an ancient Latin legal mumbo jumbo phrase. So if you need me to send that, email that to you. I'll be happy to do it. I
Okay.
will not even ask you for a writing co-credit, a co-writing credit. All right, so you were getting to sensing, but I don't want to get there yet because
Okay.
what we have here is a situation, and every lesson is learned the hard way. So a
Mhm.
little bit of a background, which is Mark and I were came on to work on a sentencing case in a fraud, bribery, construction. It was a wire fraud case, and we, as often is the case, come into the case when after a plea has already been negotiated, or a client has already pled guilty, so they're pending sentencing, and that's our area of specialty is sentencing, right? So. Flash forward, this was a situation where after a week or two after the client was sentenced, Simonelli came down, and Simonelli says, this theft of what sorry, what did we say? Honest right to control, sorry,
Right.
the
Good.
right to
Yeah.
control, which is basically this client was alleged that he had a side deal with a subcontractor that if he got that recommended that guy for a job and that guy got hired, that he would get paid. And the government called it a kickback. And but the company that they were working for said, well, if we would have known about your little side hustle with this guy, that you were paying him for the work, we never would have hired that guy to do the work. And there was no allegation that the price was unreasonable or the work wasn't completed
Mhm.
on time, on budget, and to spec. The work
Yeah.
was done. So they weren't deprived of what's called a traditional property right, which is
Right.
what Simonelli says has to happen. You have to be screwed out of something tangible.
Right.
The
Right.
fact that I didn't tell you something, i.e., an omission or a
Mhm.
misleading fact, doesn't cut the mustard. So what we
Right.
had was a situation where after a guy's pled and sentence, the Supreme Court finally rules on Simonelli and says, what he did, not a crime.
Right.
So now you've got a guy who's on his way to prison and actually in prison for a crime he never committed. It didn't exist.
Correct.
And
Correct.
so we take the appeal, and in federal court, the bane of our existence is in a plea agreement is what? The
Waiver.
appeal waiver, yeah.
Mhm.
And so, like every other appeal, in most every other appeal, he had an appeal waiver, which means it says once you plead guilty, you can't appeal this issue. So we had an innocent guy with a plea agreement that said, "Too bad you can't appeal," but we appealed anyway with some very viable arguments by you and about jurisdiction and that you can
Mhm.
never waive jurisdiction over
Right.
innocence, which seems to be pretty fucking elementary. Like if you're innocent of a crime, maybe you shouldn't go to prison,
Mhm.
have to pay hundreds of thousands of dollars of
Or
restitution.
well, it was actually if they charge you of a, if the indictment charges you with something that is not a crime, like the
Yeah,
facts that they set
then
forth
there's
does not constitute a crime. It's like saying I
so there's
like
no
blueberry ice cream, therefore I committed wire fraud.
Right.
Doesn't make any sense. Yeah.
And the argument is there's no jurisdiction,
Right.
right? Okay. So
Right.
we went into the weeds on that, but simply to tell the foundational story, which is what was the big problem there. The Court of Appeal says, sorry, you waived your right to appeal and kindly fuck off without passing go and without collecting $200. But the real knife that they stuck in
Yeah.
was for prior counsel to say, look, this Simonelli case was pending cert. Like our Thompson case right now is pending cert. This
Yeah.
Simonelli case was pending cert for a few months leading up to sentencing. You could have either objected or filed something or negotiated what we call a conditional plea agreement. What is a
Mm.
conditional plea agreement?
Well, that gives you you're going to plead guilty, but you reserve your right to appeal a particular issue.
Yeah.
So basically the condition is, I am going to be guilty on condition that I do not win my appeal. So it gives
Mhm.
you a right to appeal an issue.
Yeah.
Usually, though, you see that Fourth Amendment issues, but
Yeah, like an
yeah,
illegal
we could,
search and seizure or something like
right,
that. Right.
right,
And the other thing is the prosecutor holds all the power in
yeah,
the what plea to offer. So you could ask them, say, well, I see this thing is out there and I'd like to carve out a conditional plea just on this issue. So if the Supreme Court rules in our favor, I
right,
want to appeal that. And prosecutor doesn't have to do that. They
right,
they could say yes or they could say no. And if
yeah,
they say no, then you have to decide, well, do I take the deal or do I just say go to trial or do I
yeah,
plead what we call plead open or plead
right,
straight up? But
yeah,
here's the thing. What the court was basically saying in this case, which made it a little hard pill to swallow, was that you, lawyer, better know every single possible case pending cert or even working its way up to through the
yeah.
Court of Appeals
You better be
because
clairvoyant. Yeah.
if they, yeah, you need a crystal
Um,
ball.
you need to be omniscient and clairvoyant.
Yes, because this issue, this is a crime today, but tomorrow it might not be. So you better make sure you've, you know, um, prepared for that,
Yeah.
which
Watch
is
all
so
8,000 petitions, you
right.
know.
So we can't be omniscient and clairvoyant, but we can now put this
Oh,
issue
it's the
on
right
your radar.
tequila. The right tequila, though.
Oh, yes, yes. Tequila. I haven't mentioned tequila in a lot of my. I'm not drinking that much these days.
Yeah.
I'm on a health kick. Not that tequila's unhealthy. I'm just, well, anyway, we digress. But the point is, we can't know every case, every issue, everywhere, but we can put this one on the radar of every lawyer. So this is pending cert, this Thompson
Mm,
case, and it's not just about this one statute. It could have far reaching implications. So if you have a fraud case of any kind, you should take a look at this. And if
yeah.
you haven't pled guilty, you should potentially consider that is when you are negotiating a plea. And if you have pled guilty, I don't know what would you do in that situation. What did the court want us to do if you've already entered a move to withdraw your guilty plea because or move to amend? You better work with the prosecutor to get a amended plea agreement on. I don't know, but you better
Yeah.
do something.
Well, I mean, if you already pled guilty, yeah, you could move to withdraw right now. Yeah. Remember, our facts were a little bit different. It was, after sentencing, Simonelli
Yeah,
came down.
right,
Yeah, that, yeah.
right. Well,
But
what's
at
the
any rate,
time? What do you think the timeline if they've granted cert and so how
so
long
they
do you
granted
think it's
certs.
typically going to
So,
take for this to resolve?
well, yeah, 45 days for the opening brief. So that's sometime in November 18th, I think, and then 30 days to the brief in opposition. This is on the merits brief. Uh, and then I can't remember I think another 30 days after that. So it should be fully briefed by January. So my guess is oral argument in March or April with a decision before the end of June, obviously, since it's in this term.
Okay.
Yeah.
So that's not right around the corner. I mean, I guess
No.
another possible route would be to ask to just continue the case, like put this on hold until the
Yeah.
issue is resolved, because that would determine whether there's even a crime on the table. I don't
Mm.
know. I don't know if a judge would go for that or a prosecutor, but we have to be creative in our approaches here. And if there's a potential that it could really impact whether you even have to be convicted of a crime at all, it's worth
Yeah.
taking a closer look at. Now, okay, so now we can talk about. So I think, did I miss anything with the plea thing? Because we got to
No.
talk about. Okay, so big plea implications here, and
Yes.
also potential huge sentencing
Huge.
implications. So
Huge.
tell me what
Huge.
those are.
Huge. Huge. Okay, so let's just say, for argument's sake, that you have pled guilty and that at least one of your uh, uh, counts of conviction clearly that the underlying facts clearly was a false statement. So there is a false statement back there somewhere in your offense conduct, a truly false statement. But there's also a lot of misleading statements too. We have this weird thing at sentencing called relevant conduct.
Mm-hmm.
And relevant conduct for the uninitiated, for those who haven't gone crazy yet. uh,
We have
basic,
several podcasts on this, by the
yes, we
way.
have
I could
several.
put some
Probably got to
links in
try.
the show notes if you
Yeah,
really
I'm
want
going to
your
try to
head to
make this
explode.
as simple as possible. It's basically that the court is allowed to consider pretty much any conduct pertinent to not only the offense, but the offender. And it doesn't have to be related, actually, or directly related to the offense of conviction. So it could be a whole universe of different stuff. But there's one big caveat that a lot of people I actually overlook. There's one thing that all this universe of relevant conduct must be, and that is criminal. Whatever the relevant conduct is, it must be criminal in nature. And the circuit courts of appeal are unanimous on this. So relevant conduct must be criminal conduct. It's the point here. There's this really nebulous concept of loss that drives sentencing for white collar cases. And loss generally is the amount of money that was defrauded from investors or from the bank or embezzled, stuff like that, or money laundering, the value of the funds that were laundered, things of that
Yeah.
nature. But all of that must be derived from actual criminal conduct. So if you're going to sentencing soon and you can't get it delayed until Thompson is resolved, it still would be worthwhile making the argument that any conduct that where the loss for any amount of loss that is derived from conduct that was just of a misleading nature or an omission, that isn't relevant conduct because that is not criminal conduct. Only loss that's derived from a literally false statement can constitute relevant conduct now. I would still make that argument just to preserve it, if nothing else. Maybe your judge will go along with it, or maybe your judge will say, nah, I'm going to throw everything in, but I'm going to vary downward. At the very least, it's good for a variance, and the court can take that into consideration.
Yeah.
If $10 of conduct is based upon a false statement, and the other $100,000, like in a stock fraud case or a penny stock fraud case, where it's like a pump and dump, which is the probably the holy grail of misleading conduct, of misleading statements, which would be for for stock, the pump and dump scheme. They all rest on the fraudulent statements. So if most of it's resting on fraudulent statements, you can make the argument that the court should either disregard that because of Thompson, or vary downward the number of levels equivalent to that, whatever that conduct or that loss amount constitutes. Does that make sense? I think I'm
Yeah.
getting a little too abstract. Okay.
Yeah, yeah. I mean, loss is the main driver. The loss amount is the main driver in the guidelines on these. We're always
Yeah.
looking for ways to chip away. And
Right.
relevant conduct is another one of the bane of our existence because
Yes.
so much other extraneous shit can come in. And
Right.
this is just one more potential tool to kind of scale that back.
Right.
Scale that back. So, every case is different, but the main thing is now it's on your radar, people.
Right.
Now Thompson's on your radar. It wasn't on my radar before I read Mark Allenbaugh's deeply, profoundly compelling forthcoming article in the Law 360 called Are Merely Misleading Statements Criminal? Okay, we're going to have to work on that title.
Yeah, I know. Yeah.
Oh, and this is co-authored by our colleague and
Yes.
mentor, Alan Ellis.
Yes.
Shout out to Alan Ellis,
Hey,
who's
Alan.
co-authored this article. I doubt
Yep.
Alan's listening, but if he is, we love you. Anywho, I don't know what else to say. I think this may be a world record. We got in under like 45 minutes. So I
Oh my
feel like
God, that is a world record.
it's probably time to quit while we're ahead, but did we leave
Yeah.
anything out of this discussion that we need to talk about? Or we cover it?
No, I think the only thing I would say is look out for the merits briefs. And again, the opening merits brief will be due, I think, November 18th. So
Okay.
just keep an eye out for that.
Well, it's possible that by the time this episode drops, that those will be out. So if they
Yeah.
are, or even I can update it later, but we could put some links in the show notes. And
Yeah.
when we can get this article in the hands of any of our listeners who can't get past the paywall, we'll do that too. But
Absolutely.
anyway, we're gonna do some more podcasts together, Mark and I, in the coming months. There's so much to talk about and so
Do
little
what
time.
diddy dum
Dump
diddy do.
Diddy. Oh yes, he diddy. Okay. Well, I guess then it's time for you to go enjoy your weekend, and
Yes.
I will talk to you soon. Thanks for doing this.
Okay. Thanks, brother.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.